Wellesley-Weston Lifetime Learning offers non-credit courses to seniors in the greater Boston area. For more information about WWLL and links to our videos, please go to www.llcourses.org.
We welcome Alan Schechter back to Lifetime Learning for another session. Alan is Professor Emeritus of Political Science at Wellesley, and his sessions in the past have focused on the Great Society, the dysfunction of politics in 1960, Soft Power International, and his role in the Fulbright program. He used Hillbilly Elegy as a basis to help us understand the election, and he also focused on the crisis of opioids. He is always looking for American issues to worry about. Today, the American issue Alan will look at this morning is the new Supreme Court. He will address the implications of the changing Supreme Court membership, and we welcome him back.
Good morning. I'm delighted to see so many faces I have seen before at these lectures. I'm going to talk primarily about Justice Kavanaugh and the new Supreme Court, particularly on the subject of Roe versus Wade, abortion rights, because that's the one that's right on our minds right now. It's the one that will come up, one of the first important constitutional issues to come up for potentially redefinition with the court that exists at the present time. And it's particularly interesting to talk about right now because it's exactly a week ago, 1 week ago, the Georgia governor signed the new state law banning abortion at 6 weeks, which is a violation of the terms, clearly a violation and deliberately a violation of the current constitutional doctrine on abortion. Georgia is the 6th state to pass this law, all in the last year, and there are 13 other states that are considering it now, and it's a little bit like, well, someone else has done it. You can see an effort to, well, they've done it, so we should do it also, copycat. So we will have major conflicts over Roe versus Wade coming up, not being resolved this spring, before the Supreme Court ends its session in June, but probably in the next session of the Supreme Court. So it couldn't be more relevant as a topic in American law and politics. It all comes up as a result of the intense controversy and the reason why there was such an intense controversy over the nomination and confirmation of Brett Kavanaugh to the Supreme Court, because now for the first time since the right to abortion was created in 1973, there are 5 justices on the Supreme Court, a majority, who are against abortion, but we don't know yet whether the 2 most recent justices will add to create a new majority on this topic. In other words, the other shoe hasn't dropped yet. Clearly, given the background of both Gorsuch and Kavanaugh, Gorsuch is more conservative than Kavanaugh, so Kavanaugh's a little more iffy. But 3 of them have in past years said they did not believe Roe versus Wade was a correct interpretation of the Constitution, and now there are 5, and we will see in the next year or 2 what's going to happen. Now, we're talking about this issue as an issue of constitutional law because the outcome will depend on what the Supreme Court decides, but it's really a conflict about the culture, about a broader conflict about our culture, about rights in our culture. It's a fundamental aspect of the overall battle that's going on in American society and in American politics, obviously between those who want to have liberal rights, such as the right to abortion, and those who want to restrict those rights. I would argue already that even at this stage of the game, that the most significant result of President Trump's, of this president, whether or not he is reelected a year and a half from now, the most important result will turn out historically to be his ability to get 2 justices appointed to the Supreme Court, to change the majority of the Supreme Court for the first time since Dwight Eisenhower put Earl Warren on the court, that is in basically our adult lives. And the success of Mitch McConnell in getting Federalist Society judges, that is judges, individuals who are approved, who are recommended by the Federalist Society, that major institution of conservative lawyers, conservative justices in the country. The Federalist Society was created by Antonin Scalia. He's the originator of the Federalist Society. And there have been 100 judges now, lower court judges, approved by the Senate, who are members of the Federalist Society under the Trump administration. So you can see it's not just an occasional pattern, it's a very definite pattern, and the potential for influence on the next several decades of American law and American politics, potentially culture, results from that enormous power. And the question is, how did we get here? That's what's most interesting at the moment. So what I want to do today is to give you a little background and then go into what's going on right now. I want to talk about the origins of this right. I want to talk about its evolution since it was created, because that's what's been most interesting in the last several decades. And finally, I want to talk about what's going on in the field of abortion itself, the science, the medicine, the role of scientific innovation in dramatically preventing pregnancy and stopping it after conception, because that's an aspect of this that you don't read about in the New York Times when you read about Georgia and the other states passing. In other words, the papers, Washington Post, New York Times, Fox News. Fox News had a big article on the Georgia approval of the new fetal heartbeat law. But they're not talking about what is going on in terms of abortion rates. Teenage abortion, most of us think, because we know quite a bit from the past, that the problem is mainly centered with irresponsible teenagers. But one needs to talk about what is going on underneath the battle over the legal issues. So first, the background. The battle over the right to abortion is a classic example of American federalism, that is, the relationship between the federal government and the states. No other Western country resolves questions such as the abortion battle via the decisions of 9 people, in this instance, potentially the decision of the last appointee to the Supreme Court. The Italians, for example, 100%, 99% Catholic country, they resolved the abortion problem against the position of the Pope by having a national vote on whether or not abortion should be legal in the country. The population voted yes, it should be legal, and that's the end of the matter. It cannot be revisited unless there were a demand for a new national vote. In other words, it's done through a democratic principle, if you wish to put it in those terms, versus this not democratic principle of the power of our American Supreme Court. But that's the reality of American politics. We were all taught in school that the Bill of Rights, the first 10 amendments, protected us against government abuse. You remember that. I certainly remember that. But it's wildly oversimplistic, and I didn't know that it was wildly oversimplistic until I got to college, began to study some of these issues, and then at law school. The authors of the Bill of Rights were anti-federalists. They were very worried that the new federalist government that was being created after the Articles of Confederation failed, and there was a need for a stronger central government. So there was support for the stronger central government in Massachusetts, in Virginia, in New York, etc. And in order to get the Constitution adopted, there was an effort made to compromise that would bring in states that were against or were dubious on the subject. Sounds familiar, of course. That's what's lacking now, the ability and willingness to compromise. But at any rate, the Federalists agreed that if you will support the new Constitution, we'll pass a Bill of Rights to restrict the possibility that the new federal government will be too powerful. Okay, we're making a more powerful government, but we will tell you with the Bill of Rights that it won't be overly powerful. So the result of that is that right after the Constitution was passed, under this agreement, a Bill of Rights was passed, and the Bill of Rights says specifically, explicitly, the first word of the First Amendment is Congress. Congress shall pass no law restricting freedom of speech, religion, press, etc., etc. It does not say the states, Congress, and neither Congress nor the states shall pass such laws. The states were free to make whatever limitations they wanted on rights, and the Bill of Rights did not apply to the states. And what happened in the 19th century was that the Supreme Court repeatedly said the Bill of Rights doesn't apply to the states every time the issue came up. Secondly, the Constitution did not resolve who was going to make the ultimate decision on the legitimacy of federal laws or the legitimacy of state laws. And what happened was that John Marshall and the Supreme Court, entirely appointed, 100% appointed by George Washington and John Adams, they were all Federalists. They all believed in federal power. The anti-federalists weren't included in this first group of judges on the Supreme Court. And it was John Marshall in 1803 and the rest of his court who said, we, the Supreme Court, have the authority under the Constitution to make the final decision on the legitimacy of laws in this country. It was, in a way, a coup. And they did it in a case involving a federal statute that was so inconsequential. Marbury versus Madison is the name of the case. It's the first day of constitutional law courses in law schools or in colleges at the present time. Now, in this century, you start with Marbury versus Madison because it's the fundamental creation of the power of the courts in the United States against the two other branches of government. And in the Federalist Papers, Hamilton and Madison had written, you have to worry about, first you must make a government capable of controlling the society, and then you must make sure that you control the government, the opposite side of the coin. And Hamilton said, you don't need to worry about the court having so much power if it makes this decision later on, if they decide that they're the ones who can make the final decision. You don't have to worry about it because the courts are the weakest branch of government, and that is explicit in the Federalist Papers. It's the weakest branch of government because it doesn't control the military, the president, and it doesn't control the purse, the Congress, and therefore it's going to be the weakest branch of government. Of course, it turned out it ends up being the strongest branch of government in terms of issues such as this. That power of judicial review has never been successfully challenged since 1803. It came up in an inconsequential case. It wasn't challenged at the time in a meaningful way, and it's now fundamental to American political resolution of American political problems, unique, as I say, among all the Western countries. And it's that unique power of the federal Supreme Court which created Roe versus Wade and raises the potential of eliminating or restricting Roe versus Wade. Now, for the first 130 years, the Bill of Rights did not apply to the states. What happened, as I said, all through the 19th century, what happened was there was a civil war. The Civil War led to the demand for new constitutional rights, the 13th, 14th, 15th Amendment. We're still debating. Trump wants to, for example, eliminate national-born citizenship, the rule that anyone born in this country is a citizen. Most European countries, you're not a citizen because you're born in the country, you're a citizen by blood. If your parent is a citizen, you're a citizen. Very hard to get citizenship by vocation versus blood in Europe. The 14th Amendment, which was one of those three amendments passed after the Civil War, says for the first time, states could not take life, liberty, or property without due process of law, nor deny any person the equal protection of the law. That's the fundamental limitation on state power brought in to create rights for citizens, particularly, of course, the new black citizens. The dilemma with the Due Process and Equal Protection Clause is they're not self-defining. That's why lawyers are so important in our society, and that's why lawyers tend to make a lot of money if they're highly successful lawyers, because these legal precepts here in the Constitution, but in terms of real estate law, commercial law, securities law, inheritance law, they tend not to be self-defining. There are always these new problems that come up. So very early on, the question was, what does the phrase "no state shall take life, liberty, or property without due process of law"? What do the words "due process" mean? That's extremely ambiguous. And the meaning of due process was left for future generations to decide. Clearly, the people who wrote the 14th Amendment did not mean to include women in the definition of equal protection. We know that because we had to have, they were not included in the Equal Protection Clause, they were not included in the Right to Vote Clause, because we had to pass another amendment, the 19th Amendment, exactly 100 years ago, to secure the right for women. So the right, liberty and due process and the right to vote did not, had to be defined. But starting in the 1920s, led by Holmes and Brandeis, the two Massachusetts lawyers, the court vastly expanded the meaning of the Due Process Clause, meaning they vastly limited the states by saying the Bill of Rights, parts of the Bill of Rights, like freedom of speech, applies to the states. In other words, until 1920, states were in a position where they could limit freedom of speech or any of the other rights of the Bill of Rights because the court hadn't declared that they were still using the viewpoint that the word Congress in the First Amendment means only the federal government and not the states. So what happened in the early 1920s was the Supreme Court, with Holmes and Brandeis, said the right of free speech applies to the states. Let me step back one moment just to make a point, a collateral point, which I've always found very interesting. We were all taught that the protection of against establishment of religion was one of the rights that comes from the Constitution. But did you know states had established religions into the 1830s? Established religions were only eliminated because states that had established religions decided to get rid of them, not because the federal Constitution or the Supreme Court said it's against the Constitution. So, for example, Connecticut, which we think of as a progressive state, had an established religion until around 1835. It wasn't unconstitutional. The established religion in Connecticut was Congregationalism, because, of course, that was such a dominant religion in parts of New England. So, what happened was, after Holmes and Brandeis said the phrase due process includes freedom of speech, immediately the question then becomes, well, if it includes freedom of speech from the First Amendment, does it include freedom of the press? Does it include freedom of religion? Does it include protection against establishment? Does it include protection against search and seizure? Does it include protections against self-incrimination? None of these things had been resolved. Starting in the 40s and going on from there, the liberal Supreme Court gradually said, this right is applied to the states. This right is applied to the states. These are parts of the liberty protected by the Due Process Clause. Taking the phrase liberty protected by the Due Process Clause and pouring meaning into it from its earlier ambiguity. What happened in the 60s is the liberal Warren Court applied nearly all of the Bill of Rights to the states, one at a time, in specific cases, in what is known in American law schools as selective incorporation. And while I was at Yale Law School studying constitutional law as a student, we were talking about which rights still had not been applied to the states, and I wrote my first-year paper on the subject of one of the criminal procedure rights. Of course, what's happened is this is known in law school as selective incorporation, one at a time. This is creative jurisprudence. This is not originalism. This is the sort of power of the courts that conservatives have always, judicial conservatives, political conservatives, have always been critical of. And it's characteristic of the gradual movement in our society since the Second World War in a more progressive, more rights-oriented direction. That's what's in part being threatened at the present time. In addition to incorporating the rights, that still doesn't solve all the problems of interpretation. You can incorporate the right of free speech, but what does it mean? You can incorporate, are there limits on the right of free speech? What should those limits be? A good example of expansion of the newly incorporated right, you see the layer of complexity I'm trying to draw, and is the right to counsel. Bill of Rights, you have a right to counsel for your defense if you're accused of a crime. Not applied to the states originally. What it meant originally in English law was you could bring your lawyer with you if you had a lawyer, if you could afford a lawyer. So it wasn't that you were prevented, but if you couldn't afford a lawyer, that was your tough luck. So after the court said the Bill of Rights, protection against the right to counsel, applied to the states, the Warren Court then said, and if you can't afford a lawyer, the government must provide a lawyer for you. That's an expansion of the right. The requirement that the police inform you of what your rights are when you are arrested, the so-called Miranda rule. That's an expansion on the incorporation of the rights against self-incrimination and your right to counsel. Those of us who were on the liberal side said, that's good, that's making the right realistic. Then you have all the political problems of who's going to pay for the new right to counsel. So you had incorporation and you had expansion. You can see why all of these are relevant when you get to the discussion of the right to abortion as a due process right, because it isn't specifically in the Constitution. It's a new addition to the concept of liberty, the liberty of women. And then the question comes, what does it mean as you create the right? How do you resolve the... So up until the 1960s, each state could make its own laws about marriage, the family, divorce, sexual relations, many other areas, including abortion. Congress didn't want to deal with those kinds of issues. Those were considered to be local issues. When I was 10 or 11 after the Second World War, my uncle, who had returned from the war, and he'd married a war bride in 1941 as he was going off to war. He came back from the occupation in Germany in 1948, and his wife went to Reno to get a divorce. And I asked my mother, because I knew nothing about divorce, why did she go to Reno? Why didn't she, we were living in New York City, why didn't she get a divorce in New York City? And my mother said, she has to go and spend 6 weeks in Reno because Nevada will allow anyone to have a divorce after 6 weeks, but it's hell on wheels to get a divorce in our state. She didn't use that term. And so that's why so many people went to Nevada to get divorced, because Nevada had the most liberal, the easiest divorce laws. Sounded very, very strange to me, even as a 12-year-old. Nearly every state had laws criminalizing abortion. Every state had laws criminalizing sodomy. Okay? That's the other issue of privacy and sexual relations, which we have made so much change. Most of us in this room would say that's progressive. The government shouldn't be in the bedroom. Sodomy laws were never enforced or were enforced sporadically. Gay people should be protected against being called criminals because they're engaged in non-heterosexual, non-procreative sexual relations. And ultimately from that you get the right of gays to marry. That's a major, major change in American society, as we all know, within just the last several decades. The laws against abortion that existed in all states were called the Comstock laws. They were passed during the Victorian era, a conservative era, when abortion was dangerous, when the medical development of skills to deal with unwanted pregnancy didn't exist. So part of it had to do with the danger of abortion, but the rest of it had to do with the then definition of morality. So what happened was Comstock laws existed, but rights were expanding all throughout this era, and certain issues in our culture became more and more dominant and therefore more political. Civil rights, the early battles over civil rights really didn't come to a head until the 1960s, 1964, 65, with the new laws that were passed and decisions of the Supreme Court, starting with Brown versus Board of Education. Women's rights went from backwater eras that during my childhood we accepted what existed in the society as far as black-white relations and women's position in our society. They went from backwater areas of American life to center stage. Now, the law frequently progresses by developing a new concept and then applying that concept in areas that appear to be logically related. You begin to get pressures in that direction. The key case in the field of abortion was Griswold versus Connecticut, 1965. Connecticut had a law which said married couples can't use contraceptives. It was a crime to use contraceptives. Now you can imagine the dilemmas of enforcing that law. I remember getting married to my wife in 1958, and I was at Yale Law School, so we were living in New Haven. Couldn't buy contraceptives in the state of Connecticut at the time. What the Supreme Court held in Griswold versus Connecticut is that the law violated a right of married couples to privacy that they found in the liberty of the Due Process Clause. One of the characteristics of no state shall take life, liberty, or property without due process of law was the right of married couples to have access to contraceptives. Well, of course, if married couples have a right to contraceptives, how about the unmarried couples? So within a very short time, and that case took place here in Massachusetts versus Baird, and one of my early students who went to law school was one of the lawyers, Sandy Lynch, on that case right here started in Boston, went all the way to the Supreme Court, and she ultimately was appointed years later by Bill Clinton to the First Circuit Court of Appeals. She's now a retired judge from the First Circuit Court of Appeals. The court found the right to privacy in what the majority said is a penumbra of the Bill of Rights. The reason why the right to privacy, in terms of now just contraceptives, nothing more, you see how silly this is in the sense that prohibiting the use of contraceptives is absurd. It's ridiculous. It's not going to work. It can't be enforced. People are going to ignore it, etc. They found that right by saying that the Bill of Rights, while it doesn't mention contraceptives and it doesn't mention privacy, it says life, liberty, or property. The liberty is protected in the Bill of Rights, because the Bill of Rights says you can't be forced to incriminate yourself, self-incrimination. You have, for example, your property cannot be seized, no search and seizure. These are specific provisions of the Bill of Rights, and they all involve potentially the privacy of the liberty in the form of privacy of the individual. So the word, the penumbra, applies of liberty from the Bill of Rights. You can see that this is not in no sense specific. It's an implication from one part of the Bill of Rights to another. Now, what happened was very few states at the time had prohibitions on the use of contraceptives, so nobody paid any attention to it. It was inconsequential. Again, this new right of privacy. But in the next few years, individuals and organizations committed to expanding women's rights began arguing that the due process right to privacy should include the right of women to protect them, to decide for themselves whether to terminate a pregnancy. Several progressive states, such as New York, passed state laws eliminating criminal punishment for abortion. More traditional and conservative states did nothing. What the more traditional and conservative states are doing now is passing laws to restrict or eliminate this new due process right that's existed for nearly 70 years. The court had to deal with a more complex problem when they dealt with abortion, because they had to deal with the difficult issue of whether the fetus had any rights at all, or whether this was just a right of women. And so they came up with a very difficult Solomon-like decision, dividing the pregnancy into 3 trimesters. In the first trimester, women have a fundamental right to make this decision. In the second trimester, the court can limit the right to protect the women, but the woman still has the right. But in the third trimester, once the fetus is viable, the state has the power may have a compelling state interest, that's the term that's used, a compelling state interest to restrict or prohibit abortion during the third trimester, except in cases involving the life or health of the woman. So, and that occurs at about 24 weeks. That's the point in which the state's interest in restricting abortion to protect a viable fetus was upheld by the Supreme Court. Now, if you look at it, the court at the time was essentially Protestant. The judges were essentially Protestant. Social scientists are always dealing with how do you explain why judges make certain decisions. The court was, right now, the Supreme Court consists of, for the first time in history, there are no Protestants on the Supreme Court. There are 6 Catholics and 3 Jews. And 5 of the Catholics are conservative. Of the 6, 5 are conservatives. The 6th is Sonia Sotomayor, the first Hispanic on the court, and she's on the liberal side. Where did they come up with this concept? Quickening. In British law, the British history was that a fetus had rights from the moment of quickening, which is that moment when the fetus is we don't use the word quickening, we use the word viability, but it's the same. Well, no one liked this division. Here you have a new definition of due process, and the right is compromised from the outset by this division. Women's rights activists thought that the decision was very stingy and unworkable, would add all kinds of difficulties. It's not as if viability occurs with every pregnant woman at the same time. Viability can vary with the individual. So liberals thought the pro-women's rights people thought it was stingy and unworkable. The conservatives argued that the new right had no basis in the language or intentions of the Constitution, and of course they are right about that. This is brought into the Constitution, which makes it obviously much weaker, and so that's when the battle began. After Roe, most of the political pressure came from opponents of abortion rights, because the people who favored abortion rights, the organizations, thought they had won and no longer needed to fight for change. So since that time, 1973, the battle has always been coming in from, the attackers are always from the right. The doctrine of Roe versus Wade existed from 73 to 92. It still exists, but it's been corrupted, because in 1972, the court came up with a new doctrine, and the press doesn't make that clear enough when they talk about this issue. The current doctrine is not Roe versus Wade. It's not a fundamental right to abortion during the first trimester anymore. In 1972, Pennsylvania, a relatively anti-abortion state, had passed the first attempt to limit the right beyond what came out of the 3 trimesters. And what they passed was 4 limitations on the right. And the court upheld 3 of those 4 limitations, the first 3 to be upheld. The first one said, first limitation, the court upheld the right of a state to impose a 24-hour waiting period, an informed consent provision requiring a woman to give consent, a requirement that teenagers have parental consent, and the fourth one was, and that still exists, the fourth one was the husband had to consent. And the court said, no, we don't think that is within the concept that's been created to have the husband consent necessary. You can see why that would be rather uncomfortable, hard to enforce. The wife wants an abortion, the husband has the right to refuse to allow his wife to have an abortion. And so what that meant when they upheld those 3 was the states could regulate abortion during the entire period before viability in various fashions. And if it can do it in these 3, what other limitations can they do that the court will uphold in the future? The states no longer would need a compelling interest in order to regulate pre-viability abortions. That's the 72 decision. That's the current doctrine. That's Pennsylvania versus Casey. That's the key case, and the decision was written by that brilliant Supreme Court Justice Sandra Day O'Connor, the first woman on the Supreme Court. And essentially what the doctrine says, if you reduce it, is that the state cannot pass pre-viability limitations that create an undue burden. Those two key words, an undue burden for women. So that now, of course, that raises the question, what do the words an undue burden mean? What's the content of undue burden? What fits into that pot? An undue burden versus a due burden, an excessive burden. In other words, it's slicing further the nature of this right, making it more complex. The undue burden standard is clearly not objective. It's clearly not specific. It invites further battles, obviously. So while the media and politicians right now are focusing on whether Roe versus Wade should be reversed, the actual situation is that it was already narrowed by Pennsylvania versus Casey, and since that 72 Pennsylvania Supreme Court decision, right-to-life legislatures, the 18 or 19 states, all red states that have strongly anti-abortion viewpoints in their political systems, have passed hundreds of restrictions since that time, new limitations. And let me say something about the new limitations. The one that is coming up has already come up to some extent and is the first one to come up now in the Supreme Court next year, is the state laws that require doctors who perform abortions to have admitting privileges at local hospitals. Okay, so if it's a local hospital in an anti-abortion state, the doctor may not be able to get admitting privileges, in which case he can't perform abortions even during the pre-viability. That law was thrown out by the Supreme Court by by a 5-3 vote in 2015, and Justice Roberts was one of the dissenters. He said that law should be allowed, that particular restriction. Doctors in general feel that first trimester abortions are safe, that a modern vacuum aspiration abortion with local anesthesia takes 5 to 10 minutes plus an hour beforehand preparation and an hour to make sure recovery afterwards, and therefore that the requirement of admitting privileges is really a means to accomplish the limitation rather than medically necessary and such. So the Texas law, when this was thrown out in 2015 by a 5-3 vote, said it's an undue burden. In other words, define that within the standard of undue burden. Since it closed over half of the abortion clinics in Texas and meant that 750,000 Texas women lived more than 200 miles from the nearest clinic where they could get an abortion. The first important, so that was thrown out. The first important decision on the repeal of Roe came this February, which was on the question of whether the state of Louisiana could require that doctors get admitting privileges. Again, passed for the purpose of trying to restrict, to limit. The Fifth Circuit in New Orleans said this law is acceptable. In other words, they rejected the Texas precedent and said it's acceptable. It's different because the number of women who live so far from an abortion provider, if the law is upheld, is much smaller than in Texas. So the law was about to go into effect on the decision of the circuit court that covers the state of Louisiana. It was appealed up to the Supreme Court, and if the Supreme Court had not intervened to stop the law from going into effect, it would have then gone into existence. What happened was, now you have, this is the first test with the two new judges and the 5 conservatives. What happened was Roberts joined the 4 liberals, making it 5-4. So now you had the 5 with Roberts, and what the proponents of the abortion right said: issue a temporary restraining order to prevent the Louisiana law from going into effect. Okay, so Roberts joined that, contradicting his opinion earlier in the Texas case, and they put that case down for argument at the Supreme Court level. It will be heard by the Supreme Court next year, and I very much feel that Justice Roberts is going to switch to the position he had in the Texas case already, in which case that potential limitation would go into effect. The pro-abortion rights people in Louisiana argue that there are 10,000 abortions a year in the state. There are only 4 doctors that now do abortions, and if this law goes into effect, there will be only 1 doctor in the state, and that's obviously that person can't provide that many abortions. The geographic problem doesn't exist really in Louisiana, although it might have some impact on women. Now let me go on more quickly. 26 states require women to have ultrasounds. Many of these are very restrictive. Others are just have and see the ultrasound. The lower courts have, a number of circuit courts have thrown out the ultrasound requirement, since some of them require that the doctor give details about the fetus to the woman, on the grounds that it interferes with the free speech of the doctor. The doctor shouldn't be compelled in that regard. The Supreme Court hasn't resolved that issue about the requirement of ultrasounds. So that's quite contradictory at the moment. Nearly half the states have waiting periods, usually 24 hours before an abortion can be performed. It doesn't appear to be a great limitation, but it's a limitation for the woman, the poor woman who might have to travel far, who doesn't have a car, who might not, the 24-hour waiting period means that 2 visits to the doctor are necessary. In addition to these sorts of regulations, a number of states are trying to ban abortion in either the first or second trimester, and that's what's most important right now. A prohibition of abortion at the point when fetuses can supposedly feel pain. That's the fetal pain statutes at 20 weeks. And secondly, the fetal heartbeat at 6 or 7 weeks, which is obviously the most restrictive. Georgia was the 7th state to pass a fetal heartbeat law. 21 states have fetal pain laws at the present time. A number of 6 states have gone even further and would fully ban abortion if the due process right is reversed. Mississippi, Louisiana, North and South Dakota, and as of the November election, West Virginia and Alabama. Ohio is I'm going to skip Ohio, which is a very interesting case study on this subject, and say only that Governor Kasich vetoed, when he was governor, vetoed a fetal heartbeat law because he said it violates Roe versus Wade, which clearly does under the present standard. But after that, he said he would sign a fetal pain law, up to 20 weeks, which is a restriction, but not as much of a restriction. And he did that. And the new governor said in February that he would sign the original fetal heartbeat law. That is now one of the 6 states, along with Georgia, with this more controversial provision. What will most likely happen is that the first real challenge to Roe will probably be a fetal pain case, not a fetal heartbeat case, and the Supreme Court may decide that the state has an interest in protecting pre-viability potential life when under this concept of the fetus feeling pain, which will be a further narrowing of the undue burden standard. What may very well happen, in my guess, is that the undue burden standard will be corrupted. It may be turned into a balancing test sort of standard, which reduces the protection available to women during the pre-viability period. Now, let me say a couple of words about what's happened to abortion in the country since 1970 and about the new technical scientific developments, because really that should be included. None of us know, because the press hasn't reported, that the number of abortions in the country the abortion rate has dropped 50% since 1973. In 1981, the abortion rate was 29.3 per thousand women. By 2014, which are the latest figures, it is 14.6 per thousand women. The teenage abortion rate, which is in the stereotype in our minds, has dropped even further. The teenage abortion rate back in 73 was much higher, 43 per thousand. Now it's down to 11 per thousand. So now clearly there's still a major issue. The teenage abortion rate is much higher among black teenagers than it is among white teenagers. And that's understandable if you think about the poverty issue, among other issues. What is happening is more and more women are using contraceptives, including improved intrauterine devices and hormonal implants that can prevent pregnancy for years at a time, with fertility being restored when the implants are removed. So the woman doesn't have to worry about taking a daily pill, etc. It's all taken care of for 4 or 5 years until she wants fertility restored. The top recommendation of the American College of Obstetricians and Gynecologists is now LARCs, L-A-R-C. The public does not know because the press hasn't informed us about LARCs. LARCs are long-acting reversible contraceptives, which are now used by 14% of women coming into Planned Parenthood or similar clinics, compared to 6% a decade ago. They're being more accepted. There are over 600 Planned Parenthood clinics in all 50 states, with over 12.5 million patients a year. Most of them are working class or poor. However, access to reproductive services is limited in the 19 states, including Texas and Florida, that have not expanded Medicaid coverage for poor single adults. In other words, the Affordable Care Act expanded Medicaid, it expanded Medicaid coverage for poor women. Medication abortions, consisting of 2 pills, one supervised by a doctor and the second taken at home, have become the method of choice for women up to 10 weeks pregnant. Their use is growing very rapidly. Estimates are that 6% of non-hospital abortions were terminated with pills in 2001, and over 45% now. I called Planned Parenthood in Portland, Maine, because I was up there, and learned that clinics in the state provide these pills and also perform suction abortions. What that shows is that the more the anti-abortion forces are getting more powerful, the abortion rate is dropping as a result of new medication methods. So, and then it's becoming more common now for telemedicine to be used to provide pills, the pills for self-medication for women. There's a battle over that. Well, what will we know and when will we know it on these two individuals who've been added to the court? Since they haven't clarified themselves so far, the first cases which are coming up do not confront Roe directly. Instead, they give the new majority the opportunity to narrow the undue burden test. So I think that's what will happen first, perhaps by restricting the right to the first trimester. In many cases, women do not know that they are pregnant at the time of the fetal heartbeat. And if Roe itself is reversed after the immediate short-term issues, it's important to note that that will not eliminate abortion in the country. It will eliminate a federal constitutional right to abortion, which means each state will have the right to have its own laws. Again, we reject the use of the courts as a means of restricting abortion. So in states like Massachusetts, we will continue along the same way. What will happen is in the blue states, abortion will be available easily. In the red states, it will not be available, so anyone in the red state who wants to have an abortion would have to travel to the blue states, and obviously that's a very unequal and from my viewpoint, unaccepted outcome. And my final conclusion is that if Roe is reversed, what it will do is it will create a political backlash as a result of it. More proponents of women's rights will become politically activated as part of the increased activation of women in our society in the last couple of years, who will make greater efforts to protect freedom of choice, and that will primarily be in the direction of increasing the availability of contraceptives and medication abortions, which is the direction we're going in anyway. My wife always said, Alan talks in 70-minute sentences, so I'm stopping right there. That wasn't too bad. I'm only over 5 minutes.
This is really painful to have to cut down the questions. We have time for 1 or 2 questions. Yes.
Yes, this really isn't a question. This is probably a statement.
Okay.
Rather than deal with how many abortions or the percentage per category, whether it's going up or down, is the real figure really over 60 million since Roe versus Wade in this country? It's more than 60 million abortions.
Sure. Yes. In effect, how many abortions have there been since Roe versus Wade? And the answer is a great many. 60 million, I don't know the exact number. You can Google that and find out. And all of these estimates are rough estimates, because the research on the number of abortions is not perfect. The Guttmacher Institute is the leading institute on the pro-abortion rights side that study. I've got this. That studies this, but yes, you're right. There have been enormous numbers of abortion. And it would be easy to say women should be more responsible. It'd be easy to say there should be better contraceptives. There should be long-acting reversible contraceptives for men, because the other half of the coin is the men who are involved in it. Those are all very important points. Okay, I think we have to stop.